Miigwech Darren, miigwech gay no, ibzin daigek. Nigan wasagan abet geni digo. Makwan dem. Wikwem konge bin java. Menage nimki ben eshim ben manatmak. Then nakia mapi mamasya mapi king. So good afternoon, everyone. It's great to see you still here, and I do have to applaud the cooks. That sandwich was really good in the boat. But I know I'm not on the agenda, but I was asked to, when I walked in, I was coming to listen to the speeches, and they asked me to make a speech, and then they asked me to make another speech, so now I got two speeches to make. So I don't have any pre-packaged speeches, according to one of the people, but I don't want to take up too much time either, because you do have an agenda that you need to get through. And the first part, I guess I'll speak about the repatriation of the Bonhead pipe, Pogan, that Mishomas that sits over there by the fire. It was through discussions and networking from some of the researchers, and I believe it was Heidi Boecker and Heidi Stark, and talking to Alan Corbier, had come across a notice from the Bonham's auction house in San Francisco of where this Bonhead pipe was going up for auction, along with a number of other items. And the legal counsel that was representing the Robinson-Huron Treaty had been told about this, and they got a hold of me and asking if there's anything that any information that I would need in order to take some action in trying to get this pipe back. So naturally, I went to, as I was Gimon Wikwemkong at the time, I had spoken to our council, and they provided some authority to make a bid at the auction house, and they gave a figure that they were the limit of that they wished to purchase this from the auction house. And in the meantime, we did speak to the Shinabeg Nation Grand Council Chief Patrick Madabi. We spoke to the Ontario Regional Chief and the Assembly of First Nations Chief, and sought out some support letters and had some discussions with the federal government. And it was that time they provided us with a funding source, which was the Cultural Movable Properties Act and program that they have. And they said that they would be able to expedite the application, but we had to work with the museum. So at that time, we spoke with the coordinator and the manager at Ojibwe Cultural Foundation, and they did not have museum status at that time, or they were working towards it, but did not get haven't gotten their designation yet. And so we approached the Royal Ontario Museum because one of their curators that they had was his name was Arnie Brownstone, and he had studied a number of the pipes that originated from Manitoulin. So he had a very special research background. And he was able to recognize who the potential maker of this particular pipe was. He was able to provide a narrative that was a requirement to access federal funding. And we talked to some of the ministers, Minister Bennett at the time, and to ensure that the funding was going to be made available for us when the Royal Ontario Museum completed the application, because they had to submit on behalf of Wikwemkong and Shinabeg. And part of the protocol that was also a requirement of part of accessing the funding for that program was they required an agreement that the museum was to hold any of the items that were acquired for a 10-year period, at which point they can be transferred to either a community or another institution that has the appropriate holding facilities, meaning that they're climate controlled, they can control the humidity, and to ensure that they're going to be protected and available into the future. So we met all the conditions. The auction was going to be coming up very shortly, and we had made one last effort to the auction house, and we sent a letter with the support letters from the Grand Chiefs, Regional Chief, and the National Chief, requesting that the family, the Bonhead family themselves, the ones who had put the pipe and the items up for auction, that they reconsider putting these items up for auction, because we could not predict exactly how much they would go for and who would be bidding for them. Because as you know, many of the Anishinaabe items are held in private collections, and they are, whenever they do go up for auction in these kinds of circumstances, they go to the highest bidder. And I had a limited amount available to me from the Wecquaescoong Council to make a bid. And so we sent in a letter through the auction house to the Bonhead family, asking them to reconsider. And luckily, they pulled the items off the auction block. And they entered into a negotiation with the ROM in order to arrive at a price that would be satisfactory to them, as well as that would be within the amount that the federal government was going to provide. So we're, as you know, I can't announce it because the pipe is here. We were successful. But in the meantime, we had, because of the global pandemic that was taking place, the pipe was actually supposed to be picked up by myself and one of our knowledge keepers from Wecquaescoong to pick it up in San Francisco and bring it back home to Ontario. And because there was no traveling allowed, we had to send it by courier to the museum. Then it was held there, and we couldn't travel, we couldn't get into the museum, a whole number of different factors. And finally, last spring, we were able to bring the pipe back to Manitoulin, back into Wecquaescoong, and we invited a number of our ceremonial knowledge keepers. We had some of our items there to greet the pipe in order to say Bonjour, Mishomis. We feasted it, and then we had another gathering at the OCF later that evening that was attended by a good number of the same folks that are here, including our friends from Saugeen, who actually attended at that time. And I'd shared a little bit about what I knew about the pipe myself at that time with the those that gathered. But we were very thankful that the Royal Ontario Museum was also there, because at times repatriation of items it's something very new to the museums. It's something that there is no law in Canada that provides some guidance. In the United States, they have the NAGPRA. Can't remember what the acronym stands for. Graves and Repatriation Act. Native American Graves and Repatriation Act, that's what the acronym is. So they have that law in place in the United States. And there has been some repatriation of items from Canada back to the rightful territories. But within the United States approach, you have to work with one of the tribal nations in the United States to help facilitate that transfer. But in Canada, there isn't a law that's in place that would allow for museums to return items, because they treat it as property, and for ourselves, it's not property. These are living beings. These are living entities that we acknowledge as being living. So one of the As a result of the curators or caretakers that brought the pipe up to visit, the initial visit, they had heard the stories. They had heard and seen the welcoming by our people of these items. And then they agreed further that they would return a month later. And it was at that time that we were having our spring ceremonies in Wikwamkong, and we brought the pipe into the lodge so that it can also greet the drums and the pipes that were gathered there. And shortly after, a discussion came from the initiated by Royal Ontario Museum that they wished to have the item permanently located on Manitoulin, which was going against their own protocol that they had signed. So they're, instead of a 10-year agreement, they were now trying to expedite it, and we welcomed that. And Naomi Reckley, who's the manager at Ojibwe Cultural Foundation, has been instrumental in supporting a lot of the historical knowledge transfer within Wikwamkong and now Manitoulin and amongst all Anishinaabe. Been working together for many years, and I think she's on her third master's now, where she's doing. So she only had a bachelor's degree when she started working with me, and now she's doing her third master's and maybe her doctorate. I'm not sure, but she's been very instrumental in ensuring that the pipe is taken care of and available to all Anishinaabe. And I think that's something that we do need to keep in mind, that it isn't a pipe just for Wikwamkong. It's a pipe for Anishinaabe. There's as I said, there are many other items out there and in the museums, and I think it's through a collective effort with working with a number of our own institutions, our own leadership, that we can identify these items and ensure that they do get returned back to us in the very near future. But I think I'll leave it at that, I guess, with sharing of the experience of this pipe. I am still currently working with the Royal Ontario Museum in telling that story, which will be published in a museum folks magazine somewhere at some time this summer. But it also brings me good feelings to know that it's also paved the way for other communities. While we were accepting the pipe transfer at the Royal Ontario Museum this past fall, there was another community from Saskatchewan that was also entering into an agreement with the very same museum for items to be returned back to its community. And they were using the same model that we had put forward. And just recently, as of last week, Kitagan ZB, or Garden River First Nation, they also repatriated Jagwok's pipe. And we know him as one of the signatories, chiefs of Garden River at the time, and one of the lead spokespeople on behalf of the Robinson-Huron Treaty. So these things are happening, and if anyone does know of items that they may have seen in various museums or even private collections, I'd encourage you to talk to your current leadership and to create a plan in having some of these items returned back to their rightful caretakers. So that gives me a good segue to talk about my second speech. Oh, I get two bags. Not tea bags. So you heard a speech from the Ontario Regional Chief, and I guess that's probably why, well, maybe not why, I don't think they knew what the Regional Chief was going to talk about, but he did center his speech around the Robinson-Huron Treaty and the annuities litigation. And those of you who are language speakers, he didn't translate all the words into English, but I understood everything he said. And I think it was timely that I'm here as a spokesperson on behalf of the Robinson-Huron Treaty Trust to provide some information that the regional chief was indicating that community members throughout the Robinson-Huron Treaty territory have been asking about. And I guess one of the first things that I could say is I am bound by the negotiations protocol that was signed, so I have to be careful what I can share, but I will share what I need to share. And the first thing is that this particular case that was seeking to remedy the augmentation clause within the Robinson-Huron Treaty. It was a very specific mandate given to the chiefs who, throughout their discussions from about 2005 to 9, had developed a plan on how to get the attention of the Crown, meaning the Crown in the right of Canada and the Crown in the right of Ontario, because they do have specific responsibilities amongst themselves within Canada's Constitution. So what the approach that was taken was they established a trust made up of trustees identified by each of the First Nations, 21 First Nations that have been referenced, who have beneficiaries of the annuity within the Robinson-Huron Treaty. And this trust had the very specific mandate of only addressing the annuities issue. Nothing else, no other treaty-related issue. So it doesn't deal with land, it doesn't deal with any other, it doesn't deal with fisheries, doesn't deal with hunting. It's only about the annuity. And the other mandate that was provided was that they wanted to ensure that there was an opportunity to negotiate, if at all possible, but to also use the courts when necessary. And it's important that that point is stressed, because we know the courts are their system. However, the court itself has the power to mandate them into action. And through the court hearings that started to take place in 2015, there was a decision that was finally arrived at in December 21st of 2018, where the court agreed with the Anishinaabe to say that the annuity clause itself can come before the court, and in their word, justiciable. I'm still trying to figure out how to say that or what it fully means, but I think in simple terms it means that the court can be used for this specific clause to address the annuity issue. And so the court ruled in the favor of Anishinaabe. They also stated within its decision that Anishinaabe law is comparable and needs to be considered on par with the common law, their systems. So we had two very big victories as a result of that court decision. And it was mentioned here by Ontario Regional Chief that Ontario was appealing. They did appeal that stage 1 decision. The court case itself was split into 3. One was where the evidence was put forward on the merits of the case. The second stage dealt with the technical legal defenses that the Crown itself normally puts forward to say, and I think they call these latches and limitations, meaning that the the latches issue, has it been dealt with by the court previously? And there was a court case that was took to the Privy Council in England in the early 1900s. I think it was maybe 1905. Don't quote me on the date, but the early 1900s, where there was no Anishinaabe participation, and both Canada and Ontario made an agreement on who was responsible for the annuities on a go-forward basis. But there was no participation by us. So the latch issue, we end up winning in stage 2 again, because we were not participants in any of those discussions. And the statute of limitations within the common law says that 2 years is an appropriate time frame for you to bring an action before the court if you're wishing to file a grievance. And naturally, the last grievance that was essentially filed was when the annuity was increased to $4 back in 1874. In spite of all the correspondence, all the petitions, all the letters that have gone forward since that time, the only form that was going to be recognized as bringing an action before the Crown was through the courts. So the court had to hear on whether that limitation period would apply. And they also agreed with us that said that no, it doesn't apply. Not for Aboriginal cases, and specifically not for the annuities case itself. Ontario appealed that decision, that stage 2 decision also. And then last September, there was a deadline after that that decision was rendered, the stage 2 appeal from the Ontario Court of Appeal, that they had to make an application if they wished to appeal within 30 days to the Supreme Court. So they end up doing that also. They're appealing to the Supreme Court. And in the meantime, the Ontario Court of Appeal is one of the highest regarded courts of appeal in the world. They did not overturn any of the stage 1 or stage 2 decisions. So the legal team feels very confident that there isn't going to be a significant impact from a potential hearing at the Supreme Court or any decision that it brings forward. In saying all that, one of the because of the 2-track mandate provided by the chiefs in assembly when they established the trust, after the decision from the Ontario Court of Appeal came out, a letter was sent to the ministers representing Ontario and Canada with another further offer to negotiate, which they did accept. So exploratory discussions had happened, and for the first time in definitely my memory, but if anyone was alive in 1850, you may have witnessed the Crown and Anishinaabe leaders sitting in a circle and in ceremony. So the first time in our history since 1850, the ministers representing the Crown sat in a circle in Ottawa with the chiefs, and the message that they provided was that there was the political will to arrive at a resolution for the annuities case. And with that, they set the table for negotiations. And you have seen in January, late January, that there was an announcement that the Robinson-Huron Treaty legal case would be adjourned to allow for negotiations to happen. And negotiations have been happening. Last week, a week and a half ago, there was a mediation session that was facilitated by the Chief Justice from the Ontario Court of Appeal, or former Chief Justice, George Strathy, who had facilitated an agreement amongst the Robinson-Huron Treaty and Ontario and Canada that would that resolved a couple issues that were standing in the way of arriving at an agreement in principle. So currently, the legal personnel representing the Robinson-Huron Treaty and Canada, Ontario are now drafting what would be an agreement in principle. When that's going to happen, I'm not sure, because we know sometimes lawyers fight over how many I's are going to be on top of the I, or how many T's are going to need to be crossed. But we have been letting them know that the beneficiaries of the Robinson-Huron Treaty and all the communities have been patiently waiting for something to be announced. The goal is to make a formal announcement at the anniversary of the Robinson-Huron Treaty on September the 9th in Bauting. So you can look forward to that event. We hope that there's an agreement in place by then. And I guess I'll just try and address some of the other items that Regional Chief had brought up, one of them being potential disbursements or compensation, whatever form that might take. The Litigation Management Committee has hired an independent individual who has a team that is set to embark on a consultation and engagement process with the communities as well as community members. This project is called Mjinoe, and the Mjinoe is the individual that's been appointed to lead that, and his name is Justice, or former Justice, Harry Laforme, who's from Mississaugas of the New Credit, who has practiced law with First Nations, understands the common law, as he sat on the Ontario Court of Appeal, and he has taken on that responsibility and has created his team, and they will be going out and speaking with the communities, the councils, and the community members in the very near future to understand, or come to, I guess, not necessarily understanding, but to explore the thoughts and what the options are for disbursement of any settlement proceeds. Some of the principles that have been shared to date is that we need to consider the future generations. We also have to remember those that didn't receive any benefit because they are no longer with us. So we have to remember our ancestors. And there's also a third part, that negotiations haven't even commenced yet on what a go-forward annuity is going to be. So the current $4 amount is not even, the process to increase that hasn't even been identified yet. So there's still much work to do. But I think I can share that the Mjinoe and his team will be contacting each of the communities very soon, and we'll be having those discussions on what options will best consider everyone that needs to be considered. Meaning we need to consider our ancestors, we need to consider the current population, and we also need to consider those that are yet to come. because this amount, the amount that's being considered as part of an agreement, doesn't specify who the beneficiaries are, and that's one of the other items that the regional chief had mentioned about. There's still a lot of confusion in regards to who is a beneficiary. There's a number of historical events that have taken place that has a hand in who currently receives this $4 amount. One of them being as a result of marriage. Some individuals either gained the annuity or they lost it. So that's something that still needs to be talked about, and so it is part of the purview of the Mjinoe. The other is how you were registered through the band registry system. In my own case, I was registered under my mother's name. Therefore, I was considered a beneficiary of the Robinson-Huron Treaty. Had I been registered under my father's, I would not be. But in saying that, my father, his parents were beneficiaries. So I don't know how we get through all of that, other than the fact that through the compensation disbursement formula that the chiefs agreed to back in 2012, they wanted to ensure that there wasn't going to be divisions created by a financial settlement package that could potentially happen in the future. And they wanted to ensure that they considered everyone, and they wanted to make sure that there was an agreement before any amount of jonia was on the table. Because at the minute that there's funds available and not identified, sometimes we go crazy. Or I do anyway. If I have extra money, I go take it somewhere and go spend it, never to see it again. So there's another example that I'm very much aware of in Wikwam-Kong, where siblings 1 year apart, both have the same parents. One child receives it, the other one doesn't. So this whole notion about entitlement and beneficiary still has to be considered, but as part of the compensation disbursement formula that was agreed to, every single member of every single community was to be considered of being entitled to receive a benefit. So every single band member, community member, I guess I have to use the term band member, because that is the language that is part of the formula, is that the total membership, there's a percentage identified as a result of total membership and a percentage identified as a result of treaty beneficiary status, so that it all gets rolled into one lump sum. And this is the amounts that Mjinoe are going to be talking about. Perhaps not the amounts, but the concepts of what could be explored, what should be explored, what should be considered in order to ensure that the principles are maintained, that the team that's been undertaking this on behalf of all of you is that they want to make sure that it is a lasting agreement that has benefit for everyone. So when those discussions happen, I'll encourage you all to attend them, but also to keep an open mind with those principles of understanding, as we're very much aware of different kinds of petitions that have been going on throughout the territory. And I will say probably prematurely because there isn't an agreement in place yet. Nothing's confirmed. So I think they call that counting the chickens before they hatch, since there's been, I keep hearing that rooster up the hill here. So I think that's what I can share here today, is that work is getting done. Although sometimes we think it's a glacier's pace, even being involved on a day-to-day basis, but it is getting done, and it does get stressful, and we're very thankful that some of our knowledge keepers have been able to ground a lot of the work with ceremony. Every time that some of these large gatherings do take place, we either enter into our lodges, the sweat lodges, or we have a pipe ceremony before every one of those gatherings to not only honor our ancestors, but also give us the clear our thoughts in order to bring the best forward on behalf of all of the Robinson-Huron Treaty beneficiaries. So with that, I want to say miigwech for putting me on the spot. And I hope that's helpful on clarifying a little bit about what is happening and what is to happen. But the only other question I guess that I didn't answer was if there was a timeline. My best guess is 1 year. That's my best educated guess, is 1 year. So don't be going out and signing contracts for new cars or anything like that. If you see the vacuum salesman or encyclopedia salesmen knocking at your door, don't sign anything. Wait, there will be an announcements. That information will be shared with you when the time is appropriate and when there is a finalized agreement. So I'm hoping that you can share that message with your families and those that you speak with, that the announcements will come. Discussions will happen within the community. The community members will have an opportunity to provide their input with the councils once there's an announcement that a settlement has been achieved and there's a potential for, or what the potential proceeds that each community will receive from that agreement. And it's going to be up to us working with our councils to consider our ancestors, consider current issues within the community, and also consider those that are yet to come. Miigwech.